We're moving to this story now. The Human Settlements Department is currently reviewing the legislation on illegal occupation of land and houses in South Africa. The Prevention of Illegal Eviction and Unlawful Occupation of Land Act of 1998 aims to provide for the prohibition of unlawful eviction and to repeal the Prevention of Illegal Squatting Act of 1951. Now, the head of political organizing at Ndifuna Ukwazi, Buhle Booi, joins us for more. Buhle, a very good afternoon to you. Thanks so much for joining us. Now, government, particularly the Department of Human Settlements, has been speaking in Parliament as well, saying that the current legislation as it stands has a lot of challenges, but you argue differently. Take us through your views.
Greetings, Masa, and greetings to viewers at home, and thank you for having us here in studio. Masa, I want to start here that in South Africa, we have a crisis of housing. There's about between 2.5 to 3.7 million people that are on the waiting list, that are on the backlog in South Africa as we speak. And that number is expected to grow at 178,000 annually. So that paints a picture of a country that is in a crisis of human settlements. Now, the state is proposing, in the Department of Human Settlements, they're proposing the changes in the PI Act. Now, the PI Act is a piece of legislation that is called the Prevention of Illegal Evictions from Unlawful Occupation of Land Act. Now, that is a piece of legislation that protects both the occupiers and the owners of the land, to say that people in this current dispensation should not and cannot be evicted into homelessness without an order of the court, right? A person that wants to evict another person must go through the court processes to obtain an order of the court. But also it places responsibilities on both parties in terms of how they should conduct their tenant-landlord sort of relationships. Now, the Democratic Alliance last year proposed an amendment bill to the PI Act, and now it is being supported by the ANC through the Department of Human Settlements. Now, what this comes at the back of? It comes at the back of the occupations that we saw during the time of COVID-19, particularly in Cape Town, where majority of people lost their homes, where majority of people could not longer afford to pay rentals because they were laid off from work. So it is that context. And there is another context that I want to get into here, Masa. The context of the decline in terms of the provision of housing in South Africa. You'd know that in South Africa between 1998 to 1999, the state used to build about 235,000 households, homes, top structures that I'm speaking about. In 2023 financial year, the state only built about 33,000 households. And that's a huge decline from 235,000 to 33. It's a huge decline. And people are occupying parcels of land against this context of the decline in state capacity to provide homes for them. Now, the state and the DA and the ANC now through the Department of Human Settlements are of the view that people who are occupying are criminals, and they want to then amend the PI Act. And what the PI Act amendment will deal with is a criminalization of people. And the bill proposes three things. One, it proposes sanctions, criminal sanctions on people that are occupying parcels of land. So under the current legislation of PI, we know that an act of occupation is not viewed as a matter of criminal offense, but it is viewed as a civil matter. And if the law is amended now, a person who occupies land will be liable for financial offense, or rather will be fined or will be imprisoned. And the only exception in the current law where a person will be liable criminally for occupying is when they sell a public parcel of land to other and do check farming sort of things. Now, that's the only time. But people that are occupying out of the need and out of being failed by the state will be criminalized, will be sent to jail. And we feel that is wrong. It cannot be a viable way of dealing with the housing crisis that we have. And we're saying that the state, instead of being preoccupied with amending the PI Act, it should rather look at how it can provide more homes to people. And you know, Masa, that the state is moving away from top structures. By top structures, what they use to build the houses that are called RDP houses, right? They're moving away from that to providing sites and services for people. And even that site and service is spelling trouble for majority of people. So in 2006, the state would provide about 118,000 of the sites and services. But today they're providing only 25,000 of those. And there's a crisis in terms of the sites and services that the state is providing to people. And that's the context that the state must approach this question of the amendment bill. Now, the second thing, Masa, that the state deals with in terms of the amendment to the PI Act is the question of alternative accommodation. According to PI Act, no one may be evicted into homelessness. And the municipality has a role in terms of when a person is evicted, the municipality must assist that person with alternative accommodation. Now, if the amendment bill of the DA passes, what will happen is that there will be an imposition of a certain time period that a person must stay in this alternative accommodation that they will be provided. And we feel very much aggrieved by that, because it will mean that if a person is given 6 months to stay in this alternative accommodation, then that means that they might very well be again rendered homeless and go back on the streets. So
but
that's
then,
a
Buhle,
crisis
let me just come in there quickly.
that
Just to come in there quickly, when you're saying about that limited time as well and providing that alternative accommodation, giving that example that perhaps, let's say it is 6 months, and then what happens there after that 6 months. But then what are you saying that should happen? Should then the state then perpetually provide that, because already they should be providing housing? So for those people who are then removed from pieces of land that they have been occupying illegally, so then the state does find alternative accommodation. Are you saying that 6 months is not long enough? What would be a sufficient time period?
You know, I do want to give context to that statement because the period of 6 months was an example, because the determination in terms of the length of period would have to be determined by the courts. And we're saying that in the current frame of legislation, it says that people must be provided with alternative accommodation, which is temporary until the state builds more sort of permanent houses for people, so that people do not move from a trauma of an eviction and move from one form of alternative and temporary accommodation to homelessness. They must move to a home. Once a person has been evicted, that means that that person has a need for a home, and the state should then play a role in terms of moving people into more permanent and secured sort of households. That's a responsibility that the state has. But we know very well that the state is saying that they do not have institutional capacity to build homes for people. And that's why they're moving towards what you call sites and services. And we're saying that even with sites and services, what you'll be subjecting people to is continuity of informality, because people will build homes to the standard of what they can afford. And what majority of people can afford is a share, right? We're saying that the state must subsidize people and give people the right to self-build in these spaces that they're sending people to. So that's the position that we're taking.
Yeah.
And we're saying that in terms of this question around the court's discretion, because that's what they're also saying that must be amended, to say that the court has a responsibility to look at the personal circumstances, holistic personal circumstances of an individual that is going through an eviction. And it must look at those individuals before it gives an order, to say that would it be just and fair and equitable for the court to grant an eviction for a person to be evicted. Now they're saying that no, the court must look at other aspects. They must look at the health records of the person. They must look at the finances of the person, previous accommodation, and reasons for occupying. And we feel that this will be in direct conflict with people's personal information being shared. Remember, court papers are papers of public record.
Yeah.
So a status of a person in terms of their health might be exposed. A person's financial, means might be exposed. Those are things that we do not, especially the health aspect of things. We feel people would be further, victimized on those bases. And we say that that those amendments should not pass. The amendment to
All
PI
right.
should not pass holistically, because PI is the only form of protection that poor people have where the state is no longer providing housing for them.